My people, now good afternoon. My name is Remain Good Luck Osarity, and I bring you an update for court today. Today, now the 15th of May, 2025. Una know say now today appeal court called both PDP and APC may they come present their case. So normal, everybody go there today. PDP lawyers did, APC lawyers did, APC supporters did, PDP supporters did. So everywhere they cool, normal. This court different. Now court of appeal for Abuja here. So it's different. Everybody they okay. So now as we reach the court consent, they start. They introduce themselves. So PDP lawyers tell court say the judgment when tribunal give that day say that judgment not correct because the evidence when they bring come when the court themselves tribunal admits they don't use them work, they don't use them give judgments. Now the court can ask, now shows una bring this evidence, give court. Now I say yes. Say the CTC, they supply them, everything, they supply them. The court themselves admit them, they adopt them. But they can't surprise say the thing not can reflect for the judgment when the judge can't give. So now they can't tell appeal court today, say, look, make una look this thing well. Make una carry torchlight, look and well. Say evidence day, everything day. Now APC lawyer say no, say the judgment of the tribunal is correct. Make them leave am like that. So as more argument can they happen gently, now PDP lawyer say see even the relevant laws when support wetin they bring come, the CTC when they bring come, the result sheet and everything when they bring come. So now the one of the judge can say okay, when I bring those things, they can say yes. So now so they can't hear the matter. After they don't hear from both sides, they can say they hear. Say they go reserve judgment. I be say they go the day when they will deliver judgment, they will communicate to everybody and will constantly let everybody know say see how it go. Now so it be today. Now well done.
Governor Okpebholo of Edo State has prayed the Court of Appeal to dismiss the appeal filed by the PDP and its candidate Asue Ighodalo. The PDP and its governorship candidate Asue Ighodalo had approached the Court of Appeal to appeal the ruling of the tribunal, which affirmed the electioneering victory of Governor Okpebholo as the winner of the 2024 Edo governorship election. Governor Okpebholo, through his lawyer Ction, SAN, urged the court to affirm the judgments of the tribunal, which upheld his client's victory and found that the PDP and Ighodalo failed to prove their allegations that the election was marred by irregularities. Ikpeazu argued that the petitions which they filed before the tribunal and the appeal constitute a total academic exercise. He stated that the appellants conceded at the tribunal that if the votes which they claimed were wrongly added were deducted, Okpebholo and the APC will still score the majority of votes. Ikpeazu argued that as against the claim by the appellants that the serial numbers of the ballot papers were not filled on the Form EC25B, the form actually did not contain any provision of the recording of the serial number. He said what is provided for in the Form EC25B are spaces for the imputation of information on the quantity of materials received and the quantity of materials returned. Ikpeazu stated that in the form which the appellants tendered at the tribunal, the serial numbers of the ballot papers were clearly indicated. He noted that while the appellants pleaded Form EC25D in their petition, they failed to tender the forms before the tribunal. He argued that the ward collation officers are not bound by the results uploaded to the IRF portal where there is overvoting. Ikpeazu also argued the cross-appeal filed by Okpebholo and the APC and urged the Court of Appeal to allow the cross-appeal and dismiss the appeal.
The appeal against the judgment of the tribunal. Now today, they've adopted their brief of argument, while the respondents, APC, the governor, and the Inec, they responded by also arguing their brief also. Now, judgment has been reserved for a later date that will be communicated to all parties. All parties, they have canvassed their issues, and then so far so good. We see that you cannot put something or nothing and expect it to stand. all they just said is that, oh, they refuse to look at what they have brought before the court. The issue of overvoting, the issue of non-compliance with the Electoral Act, that the tribunal refused to look at it, you know. And so in the response of the respondents, they say it was a mere academic exercise. And so judgment reserved for a later.
In the same vein, Emmanuel Ukalu, SAN, for the APC, and Kanu Agabi, SAN, for the Inec, also argued in similar manner, praying the courts to dismiss the appeal and affirm the judgments of the election tribunal. Ukalu argued that the position of the law has not changed, even with the introduction of Section 73, subsection 2, and Section 137 of the Electoral Act 2022, that a petitioner alleging any form of non-compliance must call witnesses from all the affected polling units to prove the allegations. He added that where there is improper collation, one still needs to call witnesses, polling units by polling units, while arguing that Ighodalo and the APC failed to lead sufficient evidence to prove their case. Ukalu says the tribunal heard rightly when it found that the petitioners failed in this regard.